And the more precautions you take,
A very good afternoon and a warm welcome to all our viewers. I am Dr. Unnati, a member of the clinical engagement team at Docplexus. Docplexus Essentials is one of our many interesting activities that we will be carrying out as a part of our celebration for completing 8 glorious years. We have brand new segments like Docplexus Exclusive, Docplexus Surgery Suite, accredited CMEs, Master Series planned for the next 4 weeks for our dear viewers. To celebrate 8 to Infinity, the Docplexus exclusives were developed to help you, our HCPs, understand the 4 broad areas to make you practice better and increase the touch points with your patients. Based on avenues like medical, legal, brand development and clinical practice, financial and physicians' well-being, and online social presence. Today's session is focused on fallacies during diagnosis in routine practice and teleconsultation from a medical legal perspective. To enlighten us more on this topic, we have with us today Dr. Lalit Kapoor. Dr. Lalit Kapoor is a practicing general and GI surgeon for the past 4+ decades. He is also the medical director and surgeon at Shakuntala Memorial Hospital, Andheri, and chief surgeon at Suchuk Hospital and Research Center, Malad, and a consultant surgeon at ONGC. He is the founder, member, and past managing trustee of Association of Medical Consultants Mumbai, which was started in 1972. It is an association of over 8,000 consultant doctors of all specialties. Presently, he is the director of AMC India project and medical legal advisor to AMC. He is also the founder member of Forum of Healthcare Standards, a body which was established as an accreditation council for voluntary accreditation of nursing home and hospital. As a result of his efforts, almost 200 nursing homes have received accreditation certificates as on date. He is one of the most sought after medical legal consultants in the city of Bombay. He has guided and helped over 1,000 doctors to date, including GPs and consultants for legal assistance. He has fought on behalf of members of the association against false and defamatory reporting by media, including electronic media. All this assistance has been given selflessly and without any obligation whatsoever. He's a forceful public speaker and has delivered over 3,000 talks on a medical legal aspects of medical practice, which includes the implications of Consumer Protection Act on doctors and society all over India. He is a lucid writer and has written many articles on medical legal topics and healthcare issues. He is a regular contributor to many magazines, including Healthcare Management. He is the author of a very popular column in Grasp entitled Do's and Don'ts, a feature that educates doctors on the preventive aspects of medical legal problems. He's an alumnus of the prestigious Grand Medical College Bombay and was awarded 3 gold medals during his studies and has also passed this postgraduate exam with highest degree of proficiency. It's a pleasure to have you here with us today, Doctor. For all who are viewing this webinar, please stay with us till the end of the session to unlock these resources. There will be a Q&A session at the end of this session. Thank you so much.
Hello, friends. It is indeed a great pleasure to be invited by Docplexus to speak on this very fascinating subject, which is going to make a huge difference to the healthcare delivery system in this country. And the topic is telemedicine, fallacies during diagnosis, teleconsultation, a medical legal perspective. So this is what we are going to speak about. Essentially, first a bit about telemedicine itself, because unless we discuss that, we will not know what are the medical legal hazards or the points we need to take care of while practicing telemedicine. Now, the first question is, how come suddenly telemedicine has occupied center stage? Why this sudden resurgence of telemedicine? Now, you all know that the basic stimulus was COVID-19. Within 1 week of lockdown, the first lockdown, telemedicine guidelines 2020 were announced by the Union Health Ministry on 25th March 2020. These guidelines have been formulated by Niti Aayog and notified under the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002 by the governors in supersession of the MCI. And that also as an amendment of the 2002 Act, which had modified the various code of ethics. So it's good news that patients can now consult doctors via phone, video, and chat applications, including telemedicine platforms and WhatsApp, etc., quite legally without worry. Because as you know, until this happened, in fact, the telemedicine or consultation on the phone or giving advice on the phone to patients was frowned upon. Some courts had passed judgments against such kind of medicine, which was not direct to the patient, which was not in-person consultation. And though there's no doubt that telemedicine was being practiced earlier, it's a fact that people have been practicing telemedicine in some form or the other, but there was no legal status to it. And now after these guidelines have been passed, framed, it's entirely legal to do practice of telemedicine. So now doctors can be assured that it's lawful to practice telemedicine. And this is all over the world, mind you. It's internationally, the many countries where it's been happening since many, many years, and it's at an advanced stage. And it's heartening to know that at least we have made a beginning, and this is something which is going to grow tremendously. There is no doubt about that. Now, telemedicine, first of all, can happen between a doctor and a patient, a doctor and a caregiver, between a doctor and a doctor, between a doctor and a health worker. So that's the wide band of the people who can be talking to each other as far as telemedicine is concerned. Now, but please remember, one thing that a lot of people need to be cautioned is, though it's good to do telemedicine, remember that the onus of the indication for telemedicine is on you, the doctor. So the responsibility lies on you. And therefore, you have to be quite cautious and make sure that you're doing the right thing and so on. And therefore, the medical practitioner should exercise his professional judgment to decide whether a telemedicine consultation is appropriate in a given situation or no. It's not indicated, and indeed an in-person consultation is needed in the interest of the patient. So who is going to take this decision? This is the doctor himself or herself. That's very important. It's your responsibility. The registered medical practitioner, I'm reading from the guideline itself, shall uphold the same standard of care and ethical norms as in an in-person or a physical consultation, but within, of course, the intrinsic limits of telemedicine. The doctor should exercise proper discretion and not compromise on the quality of care. Now, this is important because in case you do feel even midway that you think that no, this case is not fit for telemedicine, and you'd like to palpate, you'd like to examine physically, then you should not continue with the telemedicine, and you should accordingly inform the patient, and you can terminate it. Remember, because ultimately it is you who have to decide. Now, there are certain exclusions in the guideline which very specifically and explicitly exclude the following. They exclude the specifications for hardware or software, infrastructure building and maintenance, data management systems involved, standards and interoperability. Also, use of digital technology to conduct surgical or invasive procedures remotely, which now, due to technology, is possible, is excluded from these guidelines. Other aspects of telehealth, such as research and evaluation and continuing education of healthcare workers, this is excluded. And of course, it does not provide for consultations outside the jurisdiction of India. So please remember the exclusions of these guidelines. These are excluded from the guidelines which the government has announced in March 2020. Now, what are the certain basic requirements? Firstly, telemedicine cannot be anonymous. An unknown doctor cannot be giving advice to an unknown patient or discussing his medical problems. So it cannot be anonymous. Both patient and doctor should be able to identify each other. Doctor must collect patient's personal details. Patient must know the doctor's name, of course, credentials, including qualifications, registration number, and so on. So therefore, when you are doing telemedicine, you have to make sure of the identity, both the identity of the patient, and you are entitled to ask for some proof because that is where certain problems can come up. Mr. X can do telemedicine and say his name is Mr. Y. And all the time you're thinking you're just talking to Mr. Y. So therefore, similarly, the patient may be speaking to a person who says he's a doctor. He may not be a doctor at all. And therefore, his identity has to be known to the patient, just as the patient's identity has to be known to the doctor. So this is a basic requirement. The age of the patient should be recorded. Again, there you are entitled to ask for proof, maybe Aadhaar card or whatever kind of proof. That's important. What is the age of the patient? Telemedicine consultation for minors only have to be done with identified adult family member. So in other words, you can't have a teleconsultation with a minor, anybody below 18 years of age. That would be not something that will be following the guidelines of telemedicine. Now, often people ask, what about consent? Now, the guidelines very clearly have stated that the patient's consent for telemedicine is implied if he or she initiates a consultation. Now, this is exactly the same as in a physical consultation. When a patient comes to you, he said, I want to consult you, doctor. Do you ask him to give a written consent that, yes, you want a consultation with me and you're giving me consent that I should examine you? You don't do that, is it not? So similar, why you don't do that? Because the consent is implied. The fact that he has come to you, why has he come to you? He has come to you, he wants to consult you, he wants you to examine him, and therefore he has come, and therefore that the consent is implied. So same thing with telemedicine. Once the patient asks for a consultation, the consent is implied. You don't have to say, okay, now you give a consent that you would like to do that. However, patient's explicit e-consent by email, audio, video is required if the health worker or the doctor initiates the consultation. What it means is, suppose there is a family doctor of the patient, and the patient is unable to or unwilling to carry out this conversation by telemedicine. So you could have a consultation through his doctors, through his family doctor, or even his consultant of some other branch. He wants a consultation with a neurologist or a urologist or whatever. So, but if you are going to have a via media, or you're going to have a medium for the consultation, then you need patient's explicit e-consent that yes, indeed, he'd like you to speak to his doctor or a caregiver, as they say, health worker, or a nurse, for example. Suppose there's a nurse who is looking after the patient. You can initiate a consultation, ask the nurse to ask the patient, reply, and so on. But for that, the consent is required, specific consent is required. And you, as in other things, you must maintain a record of this consent so that nobody can deny subsequently. Then, of course, the patient, after you consulted, you want to advise some drugs, medicines, then he has to be provided with a copy of the prescription perfectly on your letterhead with your registration number, and just as you would give a prescription in-person consultation. So you have to give him a copy, just like your maybe on the email, WhatsApp, whatever, but it has to be provided to the patient. If, of course, as in some cases, there is provision for sending the prescription directly to the pharmacy, then again, don't do it on your own. The patient's consent for the pharmacy of his choice should be there. Because tomorrow he should not say, oh, you sent to so-and-so pharmacy, you must be having some interest in sending to this pharmacy. So you have to ask the patient, please tell us, you'd like to be sent to a pharmacy of your choice. We have no problem. So do that accordingly. Right? Now, the guidelines have specifically made 3 lists. I won't go into the details of that, but there are 3 lists. List O, A and B. O list is the over-the-counter products, etc., which can be done. List A is to given only those patients whom you have done video consultation. They have been very specified. The list is specified. And B, of course, will be either video or audio. Those drugs you should be aware of which drugs you are permitted to prescribe in telemedicine. Then narcotic or psychotropic drugs are not allowed to be prescribed. Even the Schedule X drugs are not permitted to be prescribed. So be very sure that you are not prescribing drugs which have not been permitted as per the telemedicine guidelines. Now, what about a refill, for example? You want to add on medicines, maybe delete some medicines, etc. Now, this should be done only if there was an in-person consultation less than 6 months ago. If not, then you have to treat like a new patient and follow the procedure. Then add-on medicines should not be prescribed just like that. Okay. Then in emergency situations, any appropriate medicine which you think can be prescribed, but with the caveat that, look, please go and see a doctor and get physically checked, because there is this much and not more than that, then can be advised on the telemedicine. And so in an emergency situation, you are permitted to advise, but with the condition that the patient then see a doctor for physical examination. Then regarding fees, also they have specifically said that yes, appropriate fees can be charged for telemedicine consultation as for physical consultation. Just as you charge your fees in a physical consultation, you are perfectly within your rights to take the appropriate fees. And of course, how you get the fees is there are many methods that you have to decide mutually with the patient. And as I said earlier already, both patient and doctor have a right to discontinue teleconsultation at any stage, which means it's not only you who can say, now I don't think that we should continue this and you must come and get examined. Even the patient has a right to discontinue teleconsultation at any given stage. Now, what about these platforms? There are these digital platforms who are providing telemedicine services, and more are coming. They go on sending you messages that register on our platform, and we will give you the facilities, and we'll arrange this and that, etc., etc. Many are coming up, and they are going to increase in times to come. So those providing telemedicine services must ensure that the doctors are duly registered, which means now the responsibility is on this platform to make sure that whomever they're enrolled in their list of members is duly registered. It is their responsibility. Also, they must have some mechanism to address customer queries or grievances. Now, since it's a platform and the contact has come through the platform, if the patient has a grievance against the doctor, then of course he would go to the platform, but such mechanism must be in place to address these grievances and complaints. Also, the Board of Governors, BOG is the Board of Governors of the National Medical Council. They are the ones somebody can complain to against a platform. Suppose they complain against a platform that they are doing some illegal things or they are doing unethical things or whatever grievance somebody might have, then the Board of Governors of the National Medical Council can blacklist the platform. They can say that this platform, sorry, you are not permitted to do this telemedicine business. All right. And the other condition, which again you are already aware, but particularly in telemedicine, you have to be more careful and more sure about the fact that confidentiality of a patient's personal data is being maintained while you are doing telemedicine. And it not only the guidelines of the telemedicine would come into play if this does not happen. There are regulations of the Information Technology Act, the Indian Medical Council Act, of course, who has issued the guideline, the IT Act or the Information Technology Act, the Personal Data Protection Act, which has not yet been passed, but everybody is hoping it will be passed. And so you have to act within all these acts. Of course, the guidelines have again clearly stated that the doctor is not held responsible if technology breach or if somebody else was responsible for the leak, etc. He cannot be held responsible because it's not within his power to prevent that. Now, just as in the in-person consultation or physical consultation, you preserve your records as has been prescribed, like, for example, the record must be prescribed for a minimum period of 3 years, and so on. The MTP records have to be maintained for 5 years. So whatever periods have been prescribed already, which we all know about. They have to be, even the telemedicine records must be prescribed accordingly. Now, a doctor may consult even a specialist or a colleague for a person under his care. So therefore, somebody doing telemedicine can say that, well, let me consult a gynecologist or maybe a pulmonologist, etc. He can consult another colleague for the patient whom he is treating by telemedicine. And then, of course, there are other fields coming up like the teleradiology, telepathology, teleophthalmology, where ophthalmic conditions are being treated through telemedicine, telepsychiatry, in fact, the counseling, etc., which is quite common and it's coming up a lot because in mental health, there's not much of physical examination to that extent, and therefore it lends itself very well to the mental health telepsychiatry. And so these things, again, if they are interlinked with you, then you also have to make sure telepathology, the reports are you're going to link and you're going to get the reports, the X-ray reports, etc. So you've got to make sure that these are properly interpreted and properly advised as far as the patient is concerned. Now, doctor and caregiver. Again, the caregiver needs to have a formal authorization establishing his relationship with the patient, and this has to be verified by the patient in an earlier inpatient consultation, which means that if he says, I'm the caregiver of this patient with whom you want to do the consultation, then it should have been verified in an earlier inpatient consultation. Now, what about a nurse? As I said, even a nurse can facilitate consultation for a patient. You can also give advice for immediate relief and first aid, as we said, and of course, after advising that this should be done physically. Now, there are certain things which we have to understand as far as the medical legal angle is concerned, and you please remember that these are things which should be at the back of your mind. A doctor has to maintain the same standard of care during teleconsultation as during in-person consultation. Now, in other words, what I'm saying is that limitation of teleconsultation is no defense for medical negligence. Now, what is medical negligence? The simplest and best definition of medical negligence is deviation from the standard of care which results in damage to a patient. See, every word is important. Deviation from the standard of care which results in damage to a patient. So whether it is in-person consultation, physical consultation, or teleconsultation, you should not be deviating from the standard of care. If you do that, then you can't say, oh, look here, what can I do? This was teleconsultation and it has its limits, etc. No, you should have then abandoned the teleconsultation. So you have a big responsibility of knowing whether it is fit to do teleconsultation, and you can be accused of negligence and not have the defense that no, I can't help it. Then, well, who told you to do the teleconsultation? You should have said, okay, I'm sorry, we can't do, or don't proceed with it, right? And you are expected to know, you should know what are the limitations of telemedicine and use it accordingly. And please remember, these guidelines have come, it's not come as a law. There is no law, mind you. These are guidelines. But who has issued these guidelines? It is issued by the MCI, former MCI, now called the National Medical Council. And a patient can complain under the code of ethics, code of conduct, to a medical council and face disciplinary action. Now, this is exactly as a patient who has undergone physical consultation and feels that there was some violation of the code of ethics, just as he can complain to the medical council, similarly, the person who has undergone telemedicine consultation can complain to the medical council for an inquiry to face a disciplinary action. Now, again, this is something which has been quite clearly mentioned, that it is specifically noted that in addition to all general requirements under the MCI Act for professional conduct, ethics, etc., while using telemedicine, all actions that willfully compromise patient care or privacy and confidentiality or violate any prevailing law are explicitly not permissible. So it's not as if doing telemedicine, oh, good, now you don't have the responsibility or you can make some excuses. That's not true. And some examples of these actions, which would be termed as misconduct, are as follows. For example, a doctor insisting on telemedicine when the patient is willing to travel to a facility and or requests an in-person consultation. So in other words, don't try to push the patient into telemedicine. That we have already said, that only if he comes to you voluntarily, only then there is an implied consent. And you don't need to take a separate consent. But you don't try to push him into telemedicine. If he says, no, doctor, I will come, I don't mind, I'll come and meet you, etc. So that's very important. Then the doctor's RMP is the registered medical practitioner. If they misuse patient images and data, especially private and sensitive in nature. For example, the doctor uploads an explicit picture of a patient in the social media, etc. Holds good true anyway, that you cannot, for example, you write a paper on it and then you reveal the identity of the patient who had taken telemedicine. That would constitute ethical misconduct. Also, as we've already seen, that the specific drugs have been prescribed under the guidelines, and therefore those doctors who use telemedicine to prescribe medicines for the specific restricted list, for example, psychotropic drugs, etc., which are not permitted, if you were to prescribe, then possibly you have violated the guidelines. And extremely important, which you need to understand very carefully, that doctors are not permitted to solicit patients for telemedicine through any advertisements or inducements. You already know that under the Code of Ethics, it's unethical for doctors to solicit patients, to advertise. It's unethical, and disciplinary action can be taken if somebody makes a complaint that so-and-so doctor is advertising and saying, I'm the best doctor, come to me, and so on. So that you should take care. You can have to face an inquiry by the National Medical Council, or the formerly what was known as the Medical Council of India. Now, another thing which some of you may be knowing, but many perhaps don't, the proposal of the MCI, or rather the NCM, is they have made specific provision that those doctors in future, this is the future, not today, that those doctors who would want to practice telemedicine must get familiar with these guidelines, of course, as well as the process and limitations of telemedicine practice. And you in future, you will be required to enter this online program, which will be developed and made available by the Board of Governors in supersession of the Medical Council of India. So the Board of Governors, who are now in the National Medical Council, will initiate an online program all registered medical practitioners intending to provide online consultation will need to complete a mandatory online course, and within 3 years of its notification. Suppose it's notified next month, then within 3 years, you have to make sure that you've done this online program and got certified. And otherwise, if you have not done that, you will not be permitted to do telemedicine. This is the proposal by the council itself. But in the meanwhile, even though you don't have that online course so far, the principles mentioned in these guidelines have to be followed. And this is something that is supposed to come up. How soon, when it will come up. But once this has been notified or announced, then if you wish to practice telemedicine, you will have to qualify and get certified by this online course. Now, this is again something which many people would like to know. They are not aware, they are not clear about it, is the insurance angle of telemedicine. Now, many people ask, we all have this, all doctors, or at least most of them, have this protection under the professional indemnity insurance, which means this insurance protects you from its liability for actions done in the course of your professional work. If somebody sues you, somebody claims damages from you, goes to court, goes to consumer court, and compensation is awarded, then this professional indemnity insurance is one that protects you and compensates you for that loss. So the question is telemedicine covered by the professional indemnity insurance? That is to say, if somebody sues you in the course of telemedicine and says, and which has happened, and mind you, let me tell you, it has already started happening. We have come across a couple of cases. In one case, a urologist, a nephrologist, when he saw the reports, all reports were sent to him online, and he saw the reports and he forgot to see one report. There were some 10, 15 reports, and one report is skipped. And that was some calcium, which was extremely high already. And he should not have given calcium to the patient because he missed that report and he missed that creatinine thing. He gave further additional calcium, which he should not have. And then the serum creatinine shot up and he had to get admitted somewhere. And then he claimed all the expenses. He said, I'm filing a case against you. So, yes, if this doctor was covered under the professional indemnity insurance, then the insurance will cover this. They have clarified, because this is because telemedicine itself is legal. You're not doing something illegal. So why should they not cover it? The other question which patients ask is telemedicine covered by health insurance? That is, suppose the doctor has charged me 2,000 rupees, can I claim it from the insurance company? Or whatever expenses I incur by doing telemedicine. So again, the answer to it is yes. The IRDA, which is the regulatory body of the insurance companies, has clarified that yes, cost of telemedicine, the bills of telemedicine should be covered, and the whichever policy the patient has, that policy should reimburse those charges. So this is one clarification which many people would possibly like to know, and it is reassuring to some extent. And I think I have covered the basic issues which both medical, legal, and so in conclusion, I would say telemedicine offers tremendous benefits to both patients and healthcare providers, and is indeed the way forward for a vast country like India with so much of disparity in healthcare facilities all over the country. It is a great tool and an answer to our problems, but it should be used judiciously and prudently and make sure that in the process, you should not end up with malpractice litigation and other problems. And that is the whole purpose of this presentation. Thank you very much for the attention.
Thank you so much for that insightful presentation, Dr. Lalit. We have received some questions from our audiences and we'll try to answer most of them as our time permits. So I'll read out the first question for you. With telemedicine, how can a physician ensure confidentiality? Would a doctor be held responsible if a third party unknowingly listens to the doctor-patient conversation?
Yeah, third party, I presume, is from whose side? Third party is from the doctor side or from the patient side? Now, see, if it is from the patient side, somebody is overhearing, listening, that means that patient is consenting to it. There's very little you can do. Yes, from my side, yes, as a doctor, it's my duty to maintain the privacy. I should not allow any XYZ to be listening to the conversation. Definitely, that is part of the confidentiality, which is ethical duty of the doctor. But if the third party is from the side of the patient who is seeking telemedicine, then how is the doctor to be blamed for that? Either that person, if he doesn't want him to hear, he should not permit him to be there. So I don't think the doctor can be responsible for that third party. But for his third party, other than him or the person whom he needs, I think there's no question he cannot be held responsible.
Thank you so much for the answer, Dr. Lalit. The next question is that would you advise recording these telemedicine visits as a medical record to avoid any unforeseen litigation in the future? Would a patient who has recorded the session be considered as an evidence which is admissible in court?
Okay. Now, the first part of the question is, should you record? Yes, of course you should record. In fact, it is good for you, as well as just like in physical consultation. Don't you maintain the records? How are you going to remember what you told the patient, what you advised, what the patient asked you? So yes, it should be recorded. That is your safety. And as far as the evidence in the court is concerned, definitely it would be admissible. Now, the only thing, like any recording, see, many people ask, recording, if I record your voice, will it be admissible in the court? Now, the fact of the matter is that it's not that it is invalid in the court. It is admissible. However, what will happen is the court might say ask, or one of the parties might ask for a forensic examination. You see, because it is well known that it's very easy to doctor the things, etc. And therefore it will be admissible in the court with the whatever the forensic examination, etc. If it's ordered by the court, or if it's demanded, the affected party might say, no, I don't believe he has doctored the whole thing. So then, of course, he can demand, I want a forensic audit to be done. Is it genuine? Not like in all this data and all that. There are these forensic cyber people who will first confirm that this is indeed what had happened. But it could be admissible in court.
Thank you for the answer, doctor. And we have the last question for the day, which is, can a family member give the patient's history and details in case the patient refuses to visit or see a doctor?
Yeah, but that's what I said in my presentation, that family member has to be, of course, the caregiver and somebody authorized by the patient. If it is not authorized by the patient, then you should not agree to it. Patient may not want to visit you. That is different. But if the patient doesn't want his relative also to discuss your health problem with you, then that means he's not giving consent. And you can see the slide which I showed. It says that, yes, you have to have authorization from the patient if you want his caregiver or family member or whoever to do teleconsultation on his behalf. So that's important. But if he's unable to visit you for some reason, and he's authorizing, okay, here, this is my wife, I'm authorizing her, but that should be in writing, that kindly she will discuss with you and you advise. Yes, that is permitted. That is permitted in the guidelines.
Thank you so much, Dr. Lalit, for such an interesting presentation. I'm sure our viewers have got a new perspective of dealing with patients during teleconsultation and medico-legal aspects. And I would like to thank all our dear viewers for their immense love and support over the 8 years. And we promise to deliver more engaging clinical formats every day. Stay tuned for tomorrow's special segment, which is known as the Docplexus Surgical Suite, in which we will see a surgical demonstration of mucormycosis by Dr. Satish Jain. Until then, please stay safe, stay connected. Happy Docplex.